Good afternoon, ladies and gentlemen, and welcome to this Young Lawyers Mentorship Session as organized by the East Africa Law Society Young Lawyers Committee. Thank you for those who have taken time to join us and who are celebrating Barak. And even those who have a holiday today, especially Tanzania, but they've still made time to join this very important discussion. Our conversation today revolves around how we as young lawyers use the digital space. We are in a world where everything revolves online, and there's need to be very careful on how we use our spaces online, be it, excuse me, be it social media, be it any other digital media that you use every day. And so we brought together a team of experts to discuss this very important topic. We thank you as experts for taking this time and as moderators to speak about this very important topic. I'm not going to say much. I'm going to take this back to our moderator for the day, Mr. Laston Gulume, who will be assisted by Mr. Benjamin Jeru in moderating to take it on from here. Thank you.
Wow, thank you so much, David. It's really a pleasure to have this very short 1.5 hours interaction on a very key topic that touches us, I must say us as young practitioners. I already see the number is growing of the participants and attendees. We are over 50 plus and it is growing. So as we expect more people to join, I just wanted to share my my gratitude towards the organizing committee for pulling this together and also giving us a platform where as young practitioners we can share experiences, we can share insights as part of mentoring one another. I am reminded of an interesting scripture or wisdom in scripture that says iron sharpens iron. So this very short 1.5 hours interaction where we expect over 300 plus people who had already signed up for the webinar. We are going to be talking about this hot cake of social media. What can we do? What can't we do? And what are the ethical questions around this issue of social media? Social media ethics for young lawyers. And the context here is really not far-fetched because as young practitioners, everything you do, everything you post, everything you say, there is going to be a critic about it. And it comes back to maybe you have not seen enough years of the courtroom, you've not seen enough years of the boardroom, you've not seen enough years of interacting with the clients, or you may be thought not to know much or to know better, not to say or not to post or not to be in certain platforms. It's going to be a privilege to moderate this with my brother, Njeru Benjamin, and I'll just invite him also to just give his quick hello. We are testing and making sure that you're able to hear us in this interaction. Our speakers are already on call and we're excited to dive this right into this, but I'll invite just Benjamin to say a quick hello and we'll be moderating this with him. He will be in the background. He will be picking up on the hands that are being raised, on the comments that are being asked, on the Q&A, the questions that are being asked in the Q&A. So friends, as we go through this interaction, we welcome you to, since we are talking about social media and digital platforms, Zoom is one of the digital platforms. So you can exercise a bit of knowledge on how to use this digital platform as you post in the chat, you post your welcome remark, post the country where you're logged in from, so that we know as we are interacting with one another, we know who is logged in from where. And in the Q&A section, when you go to the different functions that if you're using your laptop and you scroll down, it will just display, it will display speaker, it will display the icon of the video, the participants, then there's the Q&A. You can post in the Q&A, post a question that you may have, and then in the chat, the general chat, you can just post a comment, or you can just say a quick hello as we are gathering the different people who are logging in. I want to take this privilege also to welcome our speakers who are online. Thank you so much for creating time to be part of this discussion and mentorship series. It's amazing when we listen and hear from one another and learn from one another's experiences and learn from one another where we have knocked our feet, so that we don't do the same mistakes, or where we have had an experience and learned either from another person whose shoulders we stood on. We share those experiences so that we are able to make one another better. I want to share this interesting quote. I was listening to one of our colleagues at office share a story of how they have gone through their legal practice. And they told me, last on, you can either choose to go through legal practice by making mistakes that other people have already done, or you can go through legal practice by standing on the shoulders of people who have gone before you. Thank you so much, Andrew. Andrew says that the sound is good. That is what I was waiting for. I was waiting to know that you're able to hear us loud and clear as we get started. So because we have a very short time, it's less than 1.5 hours. We only have 1.5 hours and already that time is spent. So I want to just get into setting a bit of the context of our discussion. The flyer that was shared, the email invitations that were shared were telling us that we want to be discussing the social media ethics for young lawyers and how to safeguard our digital space. And of course, in 1.5 hours, we can't handle all the aspects that come out in such a hot topic of discussion. So to just give context and to be able to utilize our 1.5 hours well, we propose that we want to just have a general quick discussion of this issue, this animal, this elephant called social media. And we want to touch a bit on the aspect of the ethics. And here we are talking from a professional platform, but interestingly, we are talking about social media, which for all intents and purposes is not regulated by our professional codes of conduct. When we are doing our professional business, we have the rules that govern our professional ethics. But yet, as members of society, as members of this global village, we are also on platforms where we interact with the world and interact with one another. And those are the social media platforms. Then, of course, we'll be talking about this digital space where people who speak very nice English about artificial intelligence and technology and all these things, how technology is being disruptive of legal practice. It's also providing ways in which people are relating. Elon Musk, from his recent endeavors and to buy off Twitter, and things are happening in the social media space, in the digital space, where the world is evolving around how the interactions in our society are being guided and are being led by technology and digitally per se. We want to talk about that following, the people who are following you and the people who you follow. And we'll be also having a bit of engagement with our speakers about these safeguards. What are they and should they be there? Is it something that is imaginary, or is it something that that a young practitioner should be aware of? We are most interested in picking your proposals on what you want us in terms of our speakers to talk about. And that's why we have the Q&A, we have the chats. You can post there, like Andrew has already posted a question there. What is the effect of social media to the practice of law? You can post those questions in the Q&A. We'll be picking them up. You can post in the chat. We'll also be able to pick up from the chat the different questions and the different comments that you'll be posting there. So we want those comments to keep coming in because we have a very short time to interact. So as you're listening in, as you have just joined, you can already post, you can already put in the chat, you can already put in the Q&A the questions that you think we should focus on or that we should not miss addressing in this interaction. We also want to pick your views, so we'll reserve some time at the end, about 15 or so minutes, where we want to pick up some hands. We want to pick up some comments from your side. If you are going to be speaking, you'll be given rights to unmute your microphone. Just make sure you are in a quiet place so that we are able to hear you well. And if you want to turn your video on, since we are talking about social media and digital space, make sure that whatever you're displaying to us for your video is one that can be recorded, because this meeting is being recorded. And in terms of if a question is posted or a comment is posted and you want to comment on it, you can always post in the comment section, and we'll be really, really happy to read out your contribution. Friends, it's not my day to speak so much. It's the day to pick from you and pick from our speakers today. We have two key speakers today, and that is none other than Benedict A. Ishabakaki. I hope I pronounced that well. Benedict is a partner in Victory Attorneys and Consultants. He's quite an accomplished fellow practitioner, as he's been around doing quite a number of big things. He's a strategic, innovative lawyer, carrying with him an aura of determination in offering tactical solutions to complex matters. As lawyers, of course, we are in the business of giving solutions to clients, giving solutions to people who pay us. And my colleague Benedict is doing that. Our other speaker today is Ribin N. Ondwari. I hope I've also pronounced that well. Ribin is a colleague from Nairobi, and Benedict is from Tanzania. So thank you, Benedict, for joining in while you're still in holiday. Ribin is a partner at Ashitiva Advocates, quite a well-accomplished fellow practitioner. I must note that he was voted as he was named the Young Lawyer of the Year in 2017. Now, 2017, you may think Ribin has been around this game for long, but that is the year he was admitted to the bar. And being able to stand out when you have just been called to the bar, of course, takes a certain breed, and you must be doing some extraordinary things. You're very much welcome, Ribin. On my side, sorry, forgive my French, I didn't introduce myself, but I had the benefit of the CEO, David, mentioned my name. My name is Laston Gulume. I work as a practice director at LP Advocates. And thank you so much, friends, for joining. I see a couple of us, we already hitting over 100 people who have joined the call. We are interested so much again and again in your comments, in your questions, so that we are able to make this 1.5 or so hours very 1.5 hours very fruitful. So I'll get into it. It's an interactive discussion. We want to ask we want to ask our speakers first to introduce themselves. As you're joining, you just mute your microphone so that your unintended submissions are not recorded. East African Law Society is recording this, so if your microphone is unmuted, you may end up making a submission that you may not intend us to capture. And I just want to call in Benedict really here. Benedict, I want you to introduce yourself to our participants. And in your introduction, I want to pick your quick thoughts on having a strong media presence as a profession. What are your quick thoughts on having a strong media presence as a profession? Benedict, as you introduce yourself, please.
Thank you, and thank you all for being part of this, debate or communication. So, as you introduced, my name is Benedict Ishabakaki. I'm a lawyer practicing here in Tanzania. Of course, I also, as you said, from my colleague from Kenya, I also named as one of most influential lawyers when it comes to governance and rule of law here in Tanzania, past few years ago. But my career before joining full practice of a law, I also used to work with human rights NGOs. I also used to work with some few international NGOs, and then I decided to establish my own practice or consultants. So without wasting a little bit time, myself, I'm a little bit, I may say I'm pro social media, and I'm very active in social media. Perhaps this the reason why East Africa Law Society chose me as one of the lead speaker. And the reason why I'm saying this is because you know, as time goes on in the world, the technology keep changing and everything keep changing. So if you look on the recent research which was done by American Bar Association, that is ABA, they say that among their lawyers, 75% out of their total lawyers, they have a presence in LinkedIn, and 65%. Can you hear me?
Yes, we can hear you now. So now welcome to Zoom. The moment someone asks, can you hear me? That's how you know you're on Zoom. We can hear you now, Benedict, please.
Okay. So I said the reason why I think our profession has to also be have a presence in social media is the fact that I wanted to talk based on research, based on facts. It's very unlucky that while doing my research, I didn't see any study which has been done by among these bar association, either Kenya, Uganda, or Uganda. But I went to do a little bit research in UK, Canada, and America, USA. So if you read the recent report which was published last year of the American Bar Association, they say that 75% of their total lawyers or members, they are using social media, either being in LinkedIn or being in Instagram or Facebook. Of course, they went further and established that some of those lawyers who are in social media, most of them, they are dormant, but most of 50%, they are active in online. And the third match or go further, and then they ask some of the clients as to where do you get your lawyers, and then also more than 60% of clients, they say, is recommendation and social media. So the reason why I'm supporting our presence, or the presence of our legal profession in social media, is number one, if we use it in a good way in terms of branding, that will be a good source of us getting business. That's number one. But also number two, if you are using it in a good way, will be also another way of us communicating with our clients. Because there's another book which, of course, I'll recommend for other young lawyers and other lawyers who practice in Africa to read. It's called Soft Skills for Lawyers. It's written by Randall. I'll share, of course, the image soon. They say one among the key elements, or one among the key soft skills which lawyer will need to keep up with the current global world is communication skills. You must be familiar with me that you know, among our clients which we handle, most of them, you may find that for those who need a quick communication, they'll say, for us to be easy to communicate, we wish to create a WhatsApp group. Because when we're on WhatsApp group, that is also part of social media. And that's why I say one among the key and effective communication, and effective soft skills for lawyers is communication. So when you find a lawyer, a client who asks you that, can I have your WhatsApp number, or can we get into groups so that we ease the communication? That is also a key element to tell you that social media is inevitable when it's come to our profession. I'll end up for now, unless now you have a specific question, then I'll have a little bit presentation on that.
Wow, thank you so much, Benedict. That was quite a very powerful and interesting introduction, coupled with statistics. It's important that we set a proper context in discussing where can lawyers communicate, how can lawyers communicate, because honestly, I have seen a number of instances, and I've witnessed a number of instances where a young legal practitioner has been told, you should not have said that, you should not have posted that, you should not have commented about that. When the big wigs are talking, and maybe they're even throwing, even on WhatsApp groups, they are throwing comments at each other, and it's okay. And you, with your keyboard warrior skills, you come and you're typing something and your name is not known. Then everyone asks, who is saying that? And if you say the wrong things at the wrong platform, usually it ends up like you have been sharing, Benedict, on communication skills, even just communication among us as peers. So thank you for that introduction. We just needed our members to know why we intentionally, as the East African Law Society and a committee that put together this team, selected a person like you, and you have really given us a proper introduction. As I invite our next speaker to introduce himself, of course, the people in these social media and digital circles know him, that he needs no introduction. I just want to thank already our participants who are participating in the chat, who are making this interactive, and those that have already posted in the Q&A, the questions that you need us to go to. Those are the questions that are going to be forming our discussion, among, of course, other discussion flow points that we have lined up. Friends, I just want to invite, in the interest of time, I want to invite Ribin, Councillor Ribin, to introduce himself and to just answer for me this simple question before we get into presentations and we get into the other bigger discussion. Ribin, as you introduce yourself, I have a question that is on my mind, and I needed to pick a brain from Nairobi since I'm in Kampala. Should lawyers be on TikTok and be posting videos on TikTok? As you introduce yourself, Ribin, you're welcome.
Thank you very much, Laston, for that question. I suspected it was going to come up due to the prevalence of TikTok among lawyers in this country. So as I've been introduced, my name is Ribin Ondwari. I'm an advocate of the High Court of Kenya. I'm advocate of the High Court of Kenya. I am a partner at Ashitiva Advocates. I head the real estate, banking, and financial services department. As Laston also said, a couple of years ago, I was lucky enough to have been named the Young Lawyer of the Year. And I can say I'm an active member in the society on a number of issues, and including online presence. Including online presence. So pretty much briefly, that's my introduction. And the question Laston has mentioned, should lawyers be on TikTok? I mean, by all means, because as lawyers, we do not practice in a vacuum. We exist in a society, and we ought to interact with it the way it is. Having said that, however, and we'll go into this in much detail when we do our presentation, there are some distinctions which then ought to exist in terms of our interaction on these social media platforms, the way they interact with us. You see, as a legal profession, we are not only operating in a vacuum, but we are a heavily regulated profession, which then means all those regulations that apply in our physical communication and physical existence actually also apply in our online interaction. So my short answer should be yes, we should be there, but then based on our regulation and the high responsibility which we hold, because most of the times our legal advice, our communication actually end up into a legal binding obligation, then we ought to abide by the legal regulations that abide by us in physical interaction. Thank you, Last.
Wow, you have already sparked us into that deep end, because when you talk about ethics for lawyers, you're talking about what the law, what the regulations prescribe. And interestingly, Ribin, when you go to social media, you don't have these regulations imported into the etiquette, the social media etiquette or netiquette that governs how we interact with the society as it is. I want to just bring in a bit of Benedict before we go to your presentation. And because of Benedict's research and because of the place that he has positioned himself in influencing matters of rule of law, and from where he has worked with international organizations, which are sensitive. They are quite sensitive on what people say, even outside the workplace, because even when you're not speaking for the organization and you are a person who is known to be affiliated to a particular organization in a professional way, there is a way that there are unwritten rules of expectation. You don't get them in your terms of reference, you don't get them in your terms of engagement, or in the client care letter, if I may put it that way, when you engage in the client. And Benedict, my question to you in terms of when it comes to branding ourselves, from what Ribin has just shared, because this is a society where we operate, this these are the platforms where we communicate with society and we communicate with our potential clientele. So regarding personal branding and social media, should we be required to draw a line between the professional life, when I'm wearing a suit, I am professional and things are okay, and my social life, when I'm on a weekend and I'm in my shorts and I am posting my photos, my TikTok videos, I'm not on LinkedIn, the professional platform. I am on the pure social platforms, on the Facebooks, on the Twitters. Benedict, should we draw a line between when I'm in office and when I'm out of office in as far as interacting on social media, as we get Fibini's presentation being prepared? Benedict, please.
Thank you. That is a very technical question. Because you know, given the circumstance of you know, the social media and the way we use social media, but I have few issues to talk. The first issue is to differentiate between a law firm and lawyers, because I understand in our practice, most of us, we have pages for law firms, but also we have pages for lawyers. You know, like for instance, my personal page. And then the second issue would be what are the risks involved while using social media. Especially, I'll give you an example, or I'll share you quite an example which exists here in Tanzania, or of course wherever. And then the other issue would be the question of social media policy. The fact that you presented a very nice question. What do you separate between personal life and professional life? But before I say that, there's a quote, of course, is from a known person, which say that there's a difference between having a brand and your identity. Okay, your identity is who you are, but your brand is who you are when the lights are on. It's not a fake you. It's as an intention version of yourself that allow you to leverage commercial opportunity. This quote is from, I just got it from social media, but I don't know who posted the same, which try to differentiate between your identity and your brand. So what am I saying? If you are using social media out of your personal, life, that I'll call it as your identity. But if you're using social media for the purpose of telling the public or prospective clients that this is a service which I'm offer, that will be called branding. So for lawyers, I think we need to differentiate between these two: identity vis-a-vis branding. If you want people to say that maybe you are a charitable person, you are very calm, you are very charming, that one you may post your personal post out of your own account, and that will call it identity. So when someone talking about Benedict, they'll say, no, most of the time he doesn't have hair, or most of the time he smiles. That will be my identity. But if I use my social media, my account, to post, that I practice commercial or I practice this and this, that will be intentional, brand, an intentional me, which I want people to perceive me. So people will say all the time when you see Benedict is in suit, that is brand, because I post everything intentionally for the people or for prospective market to see that who am I. So you need to differentiate between the two. But in the current market here in Tanzania, of course, and also in East Africa, especially I may say maybe in Tanzania, our professional ethics and etiquette regulation, they do allow a limited kind of marketing. So in a way, in the way they are drafted, they don't differentiate between a law firm, whether this is a company or a partnership, vis-a-vis an advocate. Because if you read now Rule 127 of our professional conduct of etiquette and regulation, it says an advocate may seek business in a manner which is not inconsistent with public interest or does not compromise integrity and dignity of profession. And that's where there is a challenge. In a manner which does not compromise integrity of the profession and the dignity of the profession. But in terms of other marketing, for instance, for a law firm or a lawyer to have website, to have social media, to have WhatsApp, to have Twitter, that's one we're not prohibited. The only thin line which come here and people which fail to balance is when it comes to issue of integrity and dignity. So so long as, of course, we allowed to have this social media account, but I hope, I may say, you know, like judges, if I may go further, like judges, they recently, of course, if you read some papers under the UN, they also be given a kind of guideline which safeguard their usage of social media, because you know there's been a very big debate in the international level whether judges also should join social media or not. And that's why right now, under the Global Judicial Integrity Network, there's something called non-binding guideline on the use of social media by judges. But I haven't seen any binding regulation by lawyers. The only thing which, of course, we use as lawyers, especially young lawyers, when we post issues, is to make sure that we are following our professional code of conduct. For instance, here in Tanzania, I've already mentioned the specific law. But now, how do you differentiate between your personality, the you know, your family life, you know, you having fun, vis-a-vis the branding or the usage of social media to create commercial leverage? That is where there's a thin line. I may give you an example. If you have a client list of base, you normally will save the number, they'll save you as number. So if you post your status in WhatsApp, let's say, for instance, or TikTok, as you say, and I have to declare I never posted any status in WhatsApp because I know the implication. So the question is, you have clients who are from Europe. Sometimes you have clients who are from Africa. Let's say you have, you have a mix of clients, Indians, Africans. So for instance, if you have your own personal opinion regarding a certain issue, and then you post in status, assuming that you have another client who may follow up your status, that may also cause a kind of course, it's your personal life, it's everything, but assuming you posted something which may tend to hurt your client, that will be a no-go for you. So what I'm saying, so long as I'm a professional lawyer, that is my position. I think we are supposed to be a little bit limited in terms of how we use social media. That will be my conclusion for now. And the reason why I'm going to present it later on the risk of why social media can be damaging into our personal life, but also official life.
Okay. You're already generating quite a number of comments in the chat. I see people are responding and weighing in on what you have shared. And that's where we are leading the discussion, that at the end of the day, as professionals, how do we use this digital space? How do we harness the opportunities that come with these digital innovations? But also, when we are mindful of our profession, how do we exercise our civil liberties? How do we exercise our freedoms? How do we live lives that are not boring? As lawyers, many times I have interacted with people outside the legal circles, and the idea they have about who a lawyer is, when they meet us, when we have gone for ELS conferences and they are seeing us spending some money and, you know, going to these wonderful beaches and being social, and they're seeing all these pictures going around on Facebook, on Twitter, on the TikToks, on the LinkedIns, on all this, on the WhatsApp statuses, like Benedict said, they get shocked that, oh, lawyers actually have a life. Yes, lawyers, we have a life. The question we are discussing this afternoon is, how do we have that life when we are not compromising on our professional expectations? As you come in with your presentation, Ribin, I want you to give some thoughts on this statement of conduct and becoming of an advocate, as you're giving us your presentation within the context of using social media and opportunities and the threats and the risks in social media as a way of communicating. You are very much welcome, and over to you, Ribin.
Thank you very much. I don't know if you're able to see my presentation. Thank you very much. So I'll just keep the first 2 pages because those ones really relate to the introduction, which we've already done. So pretty much I have prepared a bit of a presentation that covers a number of questions that have been raised, including this last one that Laston has shared. And really, to begin with, I was asking myself, why this discussion? Why even have this discussion to begin with? And based on the previous question that we've covered, is that at the end of the day, as lawyers, we don't operate in a vacuum. We are part of the society. And by virtue of being part of the society, if the society has gone online, then we are also going to go online. So very much social media is an important factor in both our professional and personal lives. And I like the fact that Benedict has really made a very good distinction between these two. However, while we use this social media, then we need to use it in a way that promotes first freedom of expression as guaranteed in our various constitutions and other international conventions. Number two, critically for the professional aspect that guarantees professional independence. Number three, that guarantees data confidentiality. Number four, that guarantees data protection, which has become a very big issue right now. Number five, above all, that is really guarantees civility. You know, the aspect of social media warriors and the hiding behind the keyboard is giving a lot of people the courage to lose a bit of the civility. So pretty much in Kenya, we have a very robust legal framework that can actually be said to govern this space. We have the Constitution of Kenya, which was promulgated in 2010. We have various statutes that then affect communication by advocates on social media. We have the Advocates Act, we have the Law Society of Kenya Act, we have the Data Protection Act, and there's also Computer Misuse and Cybercrimes Act, which was very controversial, and a number of its provisions were actually suspended by the High Court in Kenya because of not passing the constitutionality test. Beyond that, there's also regulations and guidelines. These are regulations under these respective acts that we've talked about. And then importantly, and in more detail, we have the Law Society of Kenya Code of Standards of Professional Practice and Ethical Conduct, which have a bit on social media. Allow me at this stage to mention that at some point, the Law Society of Kenya actually wanted to enact a specific guideline to govern social media conduct, but members overwhelmingly rejected it by the contents on which it was having. Most people felt that it was being restrictive, and the existing provisions of the law and governing guidelines actually have important regulations to cover that. So, I mean, at the beginning, any form of communication, whether physically or online, really is freedom of expression. And this is guaranteed under the various constitutions in Kenya. As I said, we have the Constitution of Kenya 2010. However, this right, while it's guaranteed, it has exceptions, so that while we are communicating on social media platforms, just as in reality, while we are protected under freedom of expression, there are exceptions. We are not allowed to do any propaganda for war. We are not allowed to participate in incitement to violence. We are not allowed to participate in hate speech. We are not allowed to participate in advocacy that constitutes ethnic incitement, vilification of others, or incitement to cause harm. Number five, we are not allowed to participate in advocacy of hatred that is based on grounds of discrimination or as contemplated under the Constitution. So at this point, it's really generally because, as we've said, social media can be used both generally or in a professional practice. And as lawyers, we are still members of the society. So we use social media even beyond our professional aspect. So generally, as we are using it, as being the professionals who are relied on to interpret the law and also the position which we hold in the society, then we ought to be very careful to ensure that we are actually promoting freedom of expression and avoiding these aspects which have been exempted. The second one is now on professionalism. And as I said, thank you, Benedict, for drawing that very good distinction, because most of the time when we are using social media, most of the time we use it for our personal issues, but then inevitably we usually straddle into the aspect of giving opinions, sharing opinions, saying as a lawyer, this issue which is happening, this is what I'd say. So there are tenets of professionalism which govern our day-to-day aspects in our physical life, and we have to remember that they follow us to our social media space. The first one is the aspect of professional independence, because as lawyers, we play a critical role in the enforcement of rule of law. Then the aspects of professional independence that we ought to maintain when handling matters, it's sort of like when you're handling a matter before a judge, you wouldn't want to be seen just hanging out with them freely or having free conversations just in public with them, because then there could be aspects of impartiality coming up. The same thing actually follows you to online, because you could be a friend or connected with a judge who's handling the matter. Same thing applies then while the duration of that case, you want to ensure you're maintaining some professional space to then ensure that that judge or judicial person still maintains the sort of authority to ensure that the judgment which they give has that space. The second aspect is integrity.
Ruben, you seem to have dropped off back there. You're on the point of integrity.
Again, sorry, last week.
Okay, we can hear you now. You dropped off while you were making the point on integrity. Take it from there.
Apologies for that. Yeah, so as I was saying, the aspect of integrity relates to you as a person holistically. And at the end of the day, for other people, the clients, the judicial bodies, regulatory aspect, the government, to rely on the aspect which we are giving, there's that aspect which your integrity ought to be maintained. As you've said, social media, it's very easy to do some actions which can call into question, but you must remember, again, this aspect, being above the fray as a professional, you also must remember to carry that out. The second aspect is responsibility, and this one is very critical, because at the end of the day, the establishment of an advocate-client relationship is something which is legally mandated. And sometimes when we are sharing our opinions online, we ought to be very careful by putting an express disclaimer and stating that you're just giving a general opinion and not advising on that particular aspect for people to actually consult their lawyers or go to their lawyers. Because then if you don't put an express disclaimer, there could be situations where an advocate-client relationship could arise, and you can find yourself in a situation where then you're being liable based on the advice you've given to third parties who you had not even directly interacted with. I mean, this is something which we did in professional ethics. I'm sure we remember that. So we also have to remember that follows us up to social media. And you see, as lawyers, we like, especially when there's a new law or case that has been ruled, to really go out there and be experts and giving that. So we ought to be very careful to make that distinction to avoid professional liability. A lot more detail on this has been shared in the IBA International Principles on Social Media Conduct for the Legal Profession. Here I've just covered briefly, so just have a look at that. The other aspect is on advocate-client confidentiality. I'll just go through this quickly. In Kenya, this is governed. There's the Advocates Act, there's the Law Society of Kenya Act, there's the Law Society of Kenya Codes of Conduct and ethical conduct. So we also have to be very careful when we are interacting on social media to ensure that we do not breach advocate-client confidentiality. Our legal profession is actually underpinned on key principles, advocate-client confidentiality being among one of them. And most of the time, this it entails a lot of aspects. I'll just briefly cover these three aspects. That the right and duty of the legal professional to keep confidential information received from and advice given to the client is an indispensable feature of the rule of law. I mean, with social media, sometimes you may want to be seen as the person who has advised someone of this transaction that has gone through very well, or someone who has advised someone in respect to maneuvering a legal aspect. But then that's really confidential information. In fact, sometimes it even goes to the aspect of even just disclosing that you're representing someone, because there could be a very critical issue that is trending on social media. Then you want to be seen as the lawyer who's actually behind that and going out and disclosing that. So we have to hold back on that, except when we have express authority from the client, because then if you just disclose that, you'll be breaching your advocate-client confidentiality. So there are exceptions to this, cases where there's qualification by the law, especially in issues of money laundering and all that. But of course, I mean, you know that there are proper channels for reporting. There are aspects where there could be that disclosure of the information would lead to prevention of commission of a crime. And most importantly, if you have consent by your client, then by all means, you can proceed to disclose all this freely. The third critical and last aspect, because I want to just also be very brief to encourage the discussion, is the Data Protection Act, which was enacted, and it has critical provision in respect to personal data, because sometimes when you're disclosing this information online, inevitably you'll end up to disclosing personal data. So in respect to the Data Protection Act, a data subject has a right under the Data Protection Act to be informed of the use to which their personal data is being put. So also it means for a client, before you disclose the information online, there's that requirement that you actually ought to inform them that if you intend to disclose the information online, you have to inform them in advance, and for them to actually give their consent, for them to be able to access their personal data in custody, in your custody. Number 3, for them to object to the processing of all or part of their personal data. Actually, a client can object to you disclosing any of their data, to correct false or misleading data. If you publish online something relating to your client or even any other person which amounts to personal data, they can actually appeal for you to correct any false or misleading information, and also to demand deletion of false or misleading data about them. This is basically under the Data Protection Act, which has been enacted. So basically, briefly, as we were discussing this discussion, I thought it would be important to lay that legal framework on those aspects which apply to us physically, but again, follow us as professional to the social media space. Thank you very much.
Wow, thank you so much, Ribin. I think there is an icon where we are supposed to be clapping hands. If we can find it, we can clap those hands, but you have the applause from my end, and I believe from over close to 150 plus and so forth participants that are already on the call. Friends, our time is fast spent. We are getting into the last 30 minutes of our discussion, and in the interest of time, this is where we begin to call in most of you who have comments, who have questions, which we've already captured, and you'll allow me read them to our panelists, and also read out the comments that have been coming through. Thank you for those hands of applause. I see quite a number of people applauding that presentation, which was a build-up from what Benedict had extensively shared. I see some hands that have been raised. We are going to get to them shortly. But in the event that you unintentionally raised your hand, you just double check so that we are sure that as we are giving you the rights to unmute your microphone, you intended to raise your hand, you're in a quiet place. And if you must turn your video on, like my colleagues Benedict and Ribin said, make sure that whatever you're displaying to us is something that can be recorded. This is being aired on Facebook, so we don't want the unintended effects of social media to catch up with you. Because I just want to invite Benedict quickly to share on the risks. The risks are there, and the risks are real. As Ribin has shared extensively, the legal framework in Kenya represents, by and large, the legal frameworks across the East African region and across the globe. I love what he cited. Was citing the IBA regulations, and those are international standards, not because there is an international regulatory body for lawyers, but it's an association, the International Bar Association, where lawyers are agreeing at an international level that there has to be some regulation, there has to be some in-house rules of how, as professionals, we interact on these platforms. So that is the very reason as why we are having this discussion. The truth is, we are aware of these regulations. We are aware of some of them need to be amended, they need reform, but they are there and they are binding on us when we are practicing. But when we put off these suits and I am in my social circles, I am attending probably a social function, I am at a birthday, I am hanging out with my friends, I'm a young lawyer, I'm a young professional, I have so much energy and so many things that I can do after I've finished my assignments. As a lawyer, you have a life and you're out there. And some of the things are ending up on platforms, which platforms you have the internet that never forgets. I am aware that employees today, even partners like you, Ribin, before they are making you partner, I am sure there are certain due diligences that are made and they are digging up things from 5 years ago. Even things before you were called to the bar are being dug up to find out what was this person's life like. Benedict, who has worked with these international organizations, these guys do thorough due diligence on the people they are working with. They want to check out the opinions we express. I was expecting Ribin to comment on the BBI decision, but I think he was careful not to go there. But when these hot discussions are out there, we are making comments, we are making opinions. And as you've said, sometimes we've not even thought about it carefully. Sometimes we are making even a loose joke. We are throwing it out there, and a person who is not in the circles, a person who is not in the profession may not even understand the white jokes that we may be throwing in there. And I want to invite Benedict, before we get to the questions that are coming from the members, to just give us a hint discussion on these risks and how do we deal with these risks that accompany us having a social media presence. Then we'll go to the comments and we'll go to the questions of the participants. Interestingly, the 1.5 hours is not too long. By the time we are done with the comments, we'll be done with our 1.5 hours. But keep the comments coming, keep the questions coming, keep the appreciations coming. It's a way of us assessing if this is something we want to do again, and we'll be happy to do it again. Benedict, you're welcome on the risks associated with social media.
Thank you. So thank you very much. And that was, of course, a nice presentation from Ribin, and of course, also a nice assessment from yourself. So part of risk, which of course I may give you a practical risk, and then also I may give you a risk based on the research which I've, of course, I've made based on the International Bar Association and other bar association in the world. So one among the practical risks, which I'm telling the truth, is that as lawyers also, as other participants say, we also need free time. And we, as part of ethics for lawyer and part of etiquette for lawyer, we also need free time for ourselves. So assuming in a circumstance, and of course this also has happened to me as I'm talking, assuming you're on a holiday, a period like this, and then perhaps you are with your family in the beach, or you went to vacation in the national park, for instance, here in Tanzania, may say Serengeti or Kilimanjaro, and then you told your client that I'm on holiday, I cannot take your call, and then assume your client saw you posting status enjoying, while your client perhaps has been called in the police. Can you take that instance? It's a direct interpretation that they may see that you are not serious. You are having fun. For them, they may not assume that you as a lawyer, you also have free time. You also have duty to yourself to relax. But for them, because normally a good language, of course, you may tell a client that, of course, I'm on holiday. For some clients, they may understand, especially if they are clients from Europe and other countries, which, of course, they do value the free time. But for our normal clients here in Africa, they'll tell you, how the hell is he? You are on holiday while I'm suffering in the police office. So the risk which I'm saying here is trust. You may lose trust from your clients just because you posted something which, of course, you're having fun. And it's unfortunate that most of us lawyers here in Africa, especially in Tanzania, in East Africa, we, for the purpose of maintaining the relationship with clients, you may not want to tell the client the truth that you're also on holiday. So you may just say, you know, I'm very busy here today and there, or there's something which, of course, is there's another matter which I'm attending. While you don't attend another matter, you're just on holiday. So I think how to cope with is just to be truthful. The client also has to understand that us as lawyers, we also have duty to ourselves. We also have to be free. So if you are on holiday, the client has to understand that he's on holiday, or if you may give him another plan B. And then the major risk now, according to studies, if you read the report from International Bar Association, IBA, they say is there's a very high likelihood of breaching client confidentiality, as Ruben has already presented it in a very good way. Because how do you now limit between the information which you share? For instance, it's a case which is ongoing in the court of law or is arbitration, and then you have shared that you won. How do you limit the information which you share, of course, for the purpose of branding yourself, but also in terms of client confidentiality? As you have, I think all of you have seen from this, we may call Big Four company in terms of accounting firms, all major deal which they sign, they'll post it online that we have signed this deal, major acquisition with this company. You know, before they do that, for them, they also have the consent to share some of the issues. But for us here who are young lawyers, perhaps you're not even part of, you know, a partner who signed that deal. But since you are part of that lawyers who took the transaction, you may feel also proud to post that you are also part of lawyers who concluding perhaps a certain mega acquisition or a certain work. So that also may also goes and cause, you know, a damage to a client or breach a confidentiality. And if you've seen in some of these countries, which of course they take very strictly the issues of code of conduct and etiquette. For example, if you go to UK, there are several cases which of course lawyers have been taken to court for tort or sometimes for breach of confidentiality just because of social media. You know, you posted something, you know, assuming that you are branding yourself, that you are part of that major deal, but the client did not give you a go ahead. So as a way forward, I may say, before you do this, make sure that the client has already given you a go ahead, and also a client has already agreed at what extent you may be allowed to share that information. So apart from client confidentiality, there's another issue, as what Robin has said, is a data breach. For a country like Kenya, of course, I understand you have the law on data protection and privacy law. Uganda, they also have a law. Rwanda, they have a law. But here in Tanzania, we still don't have the law on data protection and privacy. But our national constitution and Article 16 provide for privacy, but also our professional code of conduct and ethics also provide a very strict when it comes to issues of confidentiality and data, of course, which you receive from clients. So that is another risk which, of course, you may have. And then the last risk which I see, which is practical, is in terms of conflict of interest. So, you know, we have a few clients, you know, the similar clients I work with, these are the similar clients which, of course, someone may work with. So the fact that you may share that you date with these clients, it may be also, you know, cause your image to be, you know, someone may need to give you work, but they may not give just because perhaps they see you that you do a certain kind of cases. For instance, you know, here in Tanzania or East Africa, there are certain kind of cases if you do, and then a client say that, oh, so you are among the lawyer who represent opposition, so I may not give you that work. So those are the issues, of course, I see also, which they may be a little bit risk. But major one is data breach and confidentiality.
Well, thank you so much, Benedict. We are already in our last 30 minutes. It's already 3 p.m. and you wrapped it up quite well. The risks, the confidentiality risks, the data breach risks, and how clients sometimes are following up on us as hired guns. I remember in law school, we were being taught the concept of the duties of a lawyer, and how a lawyer, in many cases, the clients thinks that a lawyer is a hired gun. I have hired you, I am paying you, you're on call, so when I call, you ought to answer. And if you're telling me you are on holiday and you seem to be enjoying life when I'm in prison, the client may not take it lightly. And those are some of the risks that come with social media. I have noted here that we need to learn to manage perceptions. One of us has posted in the chat about the judge, in the Q&A actually, and the chat, about whether a judge, it's okay for a judge to follow an advocate on social media. And I just want to spark our questions that are coming from the participants, since we have just 27 minutes left to the end of our webinar. The first question came from our brother Kasaizi Andrew, and he was asking what is the effect of social media to the practice of law. I want to strongly believe that the presentations from our speakers, and that is Ribin and Benedict, have already touched these aspects quite in detail. But just to have a quick 1 or 2 line response from both yourself, Benedict, and Ribin, do you think, and are there any effects of social media on the practice of law? We have laid out what the law is. We have laid out what the risks are. Practically, is there an effect on how we practice the law, as social media has had an effect on how we practice the law? In 1 or so minutes from you, Benedict, and then Ribin comes.
So thank you. I think that question I've already addressed when it's come to the risk, of course, but also while I was giving my introduction on the advantage and of the social media. So it's a way, it's a two-way, it depends the way. But I want to answer the question, which of course is a very interesting question, on whether following a judge or be friendship with a judge in social media, that may amount to a kind of conflict of interest or things. So as if you read the Bangalore Principles on Judicial Conduct, these are international accepted principle for judges when like they use social media, and also how do judges will behave when they're outside of their judicial conduct. That is nothing. There's no wrong for you to be friend with judge when it comes to social media. But also, if you read this rule, which of course I told you, they are non-binding. They're non-binding rule, but of course they are very highly used by judges in globally. They call the Doha Declaration on Promoting a Culture of Lawfulness on Global Judicial Integrity Network. They say that when it comes to social media, the issue to come with whether I follow you or you follow me, that is not a literal interpretation of friendship, because that is social media. In social media, you may have friends who perhaps you don't know even them. So a friend in social media is not an actual friend in the actual context, which of course may cause a conflict of interest. And this is of course according to the non-binding rules of the Doha. So they do allow judges to have presence in social media. They do allow judges to have presence in whatever groups, but the only thing now, the limits. So if a judge knows that I have a case, Benedict has a case which is appearing before me, and then Benedict has posted a certain issue which in relating to that case, they have a limit not to comment or to do anything with that post. But otherwise, if you read this regulation, of course, and I see it in future also, we may need this kind of non-binding regulation for lawyers in terms of how do we use social media. If you read, as my brother Land Counsel Rabin has said, if you go to IBA, International Bar Association, they've already issued principles on how to behave as a lawyer in social media. Of course, they do allow people to be on TikTok, they do allow you to share status, but there are certain issues which, for instance, you are not allowed to get into debate which you don't know the depths, or if you don't know you don't have a less expertise in it. For instance, people are discussing about data protection and privacy law in Tanzania, and then you're a lawyer who perhaps do not even a P, you do other area of interest. So the time you comment, other public or client of yours, they may see that you're incompetent in that area. So those are the issues, of course, I see in East Africa and East Africa Law Society. We also need to adapt here, like create a start, also have this kind of rules, which of course may guard both senior lawyers and junior lawyers. Yeah.
Ribin, as you come in the interest of time, I want you to also handle this other elephant in the room. As you answer the effect of social media on the practice of law, as you make your comments, there is a very good question from Kenny Emmanuel Moses. He's our member from Juba, South Sudan, and a member of the South Sudan Bar Association. He has posted in the chat and is asking, how does social media fit into the role that bars advocates from advertising, since it has a potential of fetching one clients? So as you answer Andrew's question and you comment on Andrew's question on how social media has affected the practice of law, I want you to merge your response to Kenny Emmanuel's question on, there is a rule, you're not allowed to advertise, you don't print billboards. This is not USA. So how does social media fit into us complying with that rule? You're welcome, Ribin.
Thank you very much, Laston, for the question. I mean, I'll begin with the first one. How has social media affected the practice of law? In addition to what has been said, I think positively, obviously it has affected both positively and negatively. Positively, there are some two key aspects. The first one is, right now, social media has enabled quick access to information that enables us to make decision-making as lawyers, because sometimes even once a judgment has been passed or anything that you say, you see a lawyer commenting about it or someone commenting about it, you can see someone's expertise, and you can then, if you're dealing with it, like, okay, I've seen this person dealing with it, and you can call them or reach out to them for them to give you insights if it's something you're not used to it. Number two, it has connected it has really connected the world together, because at the end of the day, clients are able to link up with lawyers, lawyers are able to link up with clients, lawyers are able to link up with lawyers in other jurisdictions in a much easier way. So positively, it has affected that way. Negatively, we've talked about the aspects. So let me proceed straight to the question from our colleague in South Sudan. Interestingly, in Kenya, that rule has been relaxed a bit. There's some bit of advertising which is allowed. There was a case which was presented to challenge that provision, and thereafter there was legislative amendment which was made. I mean, same rules apply. So for like in our case where there's some bit of regulation that you can do it, but to a limited extent, then you must ensure that for posts which are meant for marketing or which could have the effect of marketing, then they abide by those regulations, because at the end of the day, it's an issue of publishing yourself and putting your qualities out there. In a case where it's completely bad, then you must then be careful to ensure that when you're commenting on something, or you're making any publication, then it's clearly an issue of general commentary on what is there, to avoid being foul of that aspect of advertising. So it really makes it much more difficult for the regulators to enforce, and obviously makes it easier for practitioners to play a bit with those regulations. But nonetheless, those rules will apply that way until updated for specific now regulation on the online platforms.
Reading your submission reminds me of interesting tax principles, tax avoidance and tax evasion.
Yes.
While we're doing our tax law, I remember our instructor being clear: advise clients wisely so that they are not caught on the wrong side of the law. But I still want to take your to pick your mind on a question from Joel Peter Namgera. We have some hands that have been raised. I see Ocheng Fanuel has raised their hand, so I will ask the technical people to pick up Ocheng, and then they are able to give Ocheng rights to unmute their microphone. I see also Rachel Magege has raised their hand, and so that we can pick their, after this question, we'll be able to go to our participants so that they can ask or make their comment, because we're in the last time of our 1 hour. We have a question from Joel Peter, and Joel Peter has raised a very intriguing question here. He says that I was reading some article about some prominent lawyers. In the article, the writer said about some lawyer that he does not believe in sharing legal information. These things of posting opinions for people to benefit from your hard work without paying for it on social media. That prominent lawyer is reported in that article that they don't share free information. And this is the question from Joel. I want to pick your mind, reading as a partner, and also later from Benedict, who is a partner. Joel is asking, what then would be the best way for a young lawyer to put himself or herself to the public with the help of social media? I think this goes to branding. how else, what would be the best way a young lawyer can position themselves to be known, to be knowing some things which are good worth listening to or seeking out for, because the senior lawyers have said, don't waste your years of law school by giving free legal advice. So what would be your quick advice to such a young lawyer? Ribin and later Benedict, before we get the participants who want to make their audio submissions. Yes, Ribin.
It's interesting, Laston. I think someone listening to you might think you're in the Kenyan legal circles, because about 2 or 3 weeks ago, there's some bit of controversy about that, where a business person had asked for some legal advice on social media, and a well-known lawyer gave the advice, and it really trended in the legal circles as to whether what he was doing was right. And he defended himself, of course, saying that he's happy to share this information. Beyond that, he's happy to do pro bono cases. So it raised a lot of controversy. And because I'm a candidate in an ongoing election, at some point I was asked what my view on it was, and I had to give a very careful answer, because at the end of the day, I still want both of them to vote for me tomorrow. I actually said what is going to be my answer right now. That at the end of the day, social media, of course, presents a whole new set of challenges which have to be addressed with, in terms of, as a society, we need to then come together and decide, where do we put a demarcation as to between general information that can be shared freely, number one, and number two, as to the legal advice which we are giving clients. Because here, at the end of the day, as a lawyer, once you give legal advice, there's that aspect where you'll be held to that professional responsibility. If you remember that point for responsibility under the IBA principle, the challenge then becomes with, as a lawyer, if you just freely share legal opinions online without putting a disclaimer that you're just giving a general commentary, some people may actually rely on these opinions, and if they rely them to their detriment, they can actually hold you accountable for professional negligence. So that's the challenge. But then my advice to my fellow young lawyers as to how we can sell ourselves out there, by all means, based on the fact that, especially right now, Kenya, we've not demarcated as to what is or is not general commentary. I think it's okay to share what you think you're okay sharing out there, provided that you put a very express disclaimer that what you're giving is general information and should not in any way be construed to be legal advice. And if someone needs specific legal advice, they should then reach out to an advocate specifically with that set of information. That's for now where it is. But going forward, I think our various societies, the Law Society of Kenya, Uganda, the South Sudan, we need to come together and then clearly demarcate these boundaries as to what do we think is important to be shared, what do we think amounts to legal opinion, before we agree this and regulate. But before then, I think it's free for parties to share. I have my own preference in terms of what is being shared or not. But then the key thing is that ensure that you have to put that disclaimer, because if you don't put that disclaimer and someone relies on it, someone who you did not even intend to communicate to, but they see that rely on it to their detriment, then you'll be held liable for it.
Wow, thank you so much. I will quickly just invite Benedict to come and give his comment on that. I know, Ribin, your potential voters have heard that commercial. I don't have the permission of the East Africa Law Society to talk about the Kenya Law Society elections tomorrow, so I've not said anything. Please, Benedict, you can come give your comment on that.
Thank you. So my comment would be, so there's something called 70-30 rule, that when you're in social media as a lawyer or a law firm, you need to dedicate, now it depends, but according to the rule, of course, and this is, as I said, they studied from UK and Canada, they say for them is that you need to make sure that 70% of your content should provide the value to the audience. And of course, the case that it should provide value does not mean that it's a free legal advice, but a kind of, awareness or, a certain campaign. and then 30% of your content should promote your firm or you yourself as a lawyer. But also that is according to international standard. I believe we do share this kind of professional conduct and etiquette. But here in Tanzania, if you read Rule 127, it also gives lawyers, a free way, as in Kenya. The rules are a little bit lax. So the lawyers can advertise themselves and can seek business. But of course, as I said previous, you only need to watch that the advertisement you are making does not compromise with integrity and dignity of your profession. And specifically, if you read the regulation, it say that for the purpose of this rule, seeking business, including advertising on business, making public appearance for the purpose of bearing one business or being interviewed on his own business, circulating literature and advertising on own business. So as you can see, nowadays the standards of lawyers, both senior and young lawyers, writing articles, posting themselves, and branding themselves in certain areas. So for Tanzania, the law is a little bit lax. It allows us to advertise, of course, subject to a certain condition. But now when you come to the international bar standard, they say at least make sure as a lawyer or as a law firm, you have a 70-30 rule. Make sure 7% of your content is influencing or creating awareness to the public, and then the 30 now will be branding to your firm. But according to international standard, the fact that you share a certain opinion or a certain literature to the public, that does not amount to giving legal advice.
And Benedict, in the interest of time, we just have 10 minutes left. So I really want to pick your thoughts before we close this. I have 2 questions left in the question and answer, and I will merge them. There is a question on young lawyers going to social media to advocate for better payment and working conditions. You are a partner at in your own practice, Victoria Attorneys and Consultants, and young lawyers say when they are joining the profession, they are not paid as well as they expect. So they end up on social media to take the battle there. And then secondly, that was from Blair. And then Rachel, who also raised her hand, is asking about the emails they send to you, partners in law firms, when they are asking for internships and you do not reply. Talking about using and safeguarding the digital space, can we just have your 2 comments on those questions? Blair is asking, is it a viable avenue to raise issues of working conditions for young lawyers on social media? And Rachel is asking, what can be done about this non-responsiveness to emails? Is this digital space worth it when lawyers don't answer emails from applicants applying for internship? I'll just pick those 2 from you before we get to the last comments in the chat. Yes, Benedict.
So I'll start with the question from Rachel Magige. She's Tanzania, and I understand she's a friend of me in LinkedIn. We are friends, and it's good that previous, of course, she texted me about looking for opportunity, and I was very immediately, of course, I answered for her. And I think she asked the question in terms of now taking as a good practice. I think the fact that you are in LinkedIn or you're in this social media as a partner or as a lawyer, you also need to understand that this platform, the main purpose is for people to look for opportunity. So if you are there in that opportunity and then someone has texted you or messaged you, I think you have a role as a lawyer or as a partner to respond. If you don't have a position, at least it would be nice for you to say you don't have that position, or nice for you to take the resume of that person and then think of them in future. Because I don't see a logic of you being in those kind of platform where people are looking for opportunity and then there are young lawyers who are texting you and then you never reply. But I may say to Rachel that now this also depending on the personality of somebody. There are people who are normally, I may not say rude, but there are people who are normally, they don't like to respond every text which they see. But there are other people who are nicely, they may respond each and everything. So that is depending on the personality of partners and also seniors. And then the other question was whether young lawyers, they should use this platform, social media, to advocate for safe working environment. I agree. And for people who follow my page in LinkedIn, I'm the one, of course, who also, of course, number one, I advocate a lot for paid internship. all my interns, which are in my office who pass, we pay them, you know, an amount which, you know, that they can get out of office or in the office, because in real sense, we also came from the other side of internship and volunteers. And the other thing is, most of this law firm, in real sense, most of this work will also be done by this intern. So I'm pro pay intern, I'm pro pay volunteers, but also I also think this is a nice opportunity and nice platform for young lawyers also to raise their concern when it's come to working environments. Yeah.
Thank you so much, Benedict. And Rachel has responded saying that this was a general question. In her interaction with you, indeed, you answered her questions. We are already in our last minutes. I don't see Ocheng Fanuel being given rights to unmute their microphone, or Rachel. So it's already the last 6 minutes and we want to keep this prompt. There are quite a number of comments that have come through in the chat. I think members have been able to follow the discussion in the chat. In our last really 6 minutes, I just want to invite our speakers, since there are no further questions and I don't see any of the participants being given rights to unmute their microphones. We just have 5 minutes and we'll just be kind enough to just invite our speakers to give their parting shots. Ribin, I am not talking about you being voted tomorrow by the Kenya Law Society, but I just want to invite you to give your parting shots as we come to the close of this interesting webinar. Yes, Ribin.
Thank you very much, Leston. Indeed, we can't talk about that here. So, pretty much, as we stated from the beginning, indeed, social media is part of the society, and as lawyers, we do not practice in a vacuum. Everything that is part of the society, we are part of it by virtue of being members of the society. The only caveat that we add is then, as professionals, first of all, when we start introducing our professional work into these spaces, and also generally because the society is used to looking at us in a particular way, then we ought to remember the guidelines and procedures that follow us in our physical engagement, and also take them to the social media engagement. But most importantly, when we share our opinions and advice online, it's important to always have the disclaimer that you're sharing this as a general commentary, because it's very, very easy to have an advocate-client relationship with someone who you did not even intend for them to have that implication, leading to a negative liability on both the party, because you did not intend to actually advise them, and you, the advocate, because you actually didn't intend to give legal advice. But having said that, social media is a good thing. It's here, it's connecting us to the world, it's giving us access to quality information, it's giving us access to connect to each other, and it's really there, and we have to be part of this, and we'll have to continue being part of this. Thank you so much. Thank you for the organizers for organizing this very informative discussion. I've also learned a lot from the questions, from the discussion, from my colleague panelists, from you, Laston, from your perspective on aspect, and for everyone for taking your time to attend this session. Thank you very much, and may God bless all of you. Thank you.
Thank you so much, Ribin. I am not aware of the Kenya Law Society regulations about campaigning at this time, but thank you so much. We appreciate your wisdom and knowledge. I'll invite Benedict to give his parting shots as our CEO, David, prepares. There is one question we have from Andrew, but it is not for us. Andrew was asking who amounts to a young lawyer and how many years of practice are considered for a young lawyer. That will go to David as David comes to give us the closing remarks since he opened. Benedict, I invite you, as we have 3 minutes left, to give your parting shots. Please, you're welcome.
Thank you. Mine, I don't have much to say. The only thing which I may say is, I think, as Robin said, social media may have positive impact, but also may have negative impact. So it depends with you. What I'll insist is that as lawyers and as lawyers who seek business, now use social media as a part of your branding. But if you're a lawyer who, you know, maybe you're an in-house counsel, or you don't need to seek any business, also you may use social media as part of creating of your identity. As I said previous, these are two separate issues, your identity vis-a-vis your brand. And then I think it's just for young lawyers and other lawyers to know the do's and don'ts in terms of usage of social media, but also for us young lawyers to make sure that we keep reading daily, because these are things which are very new. As I told you, there are a lot of publication when it comes to guidelines and principles for how to use social media for judges, for lawyers, for arbitrators. So these are things which, of course, I think most of us we are supposed to read daily so that we can understand the contents. That's all.
Thank you so much, Benedict. As I invite our CEO, David, I just want to read one comment from Herman Tambo about their feedback. They are saying that I appreciate this discussion because it introduces nouns into this conversation. Some people take very strong positions about social media, and this discussion has the breath of fresh air to show that there are many variables at play. Thank you, presenters and members, for sharing your wisdom. Friends, you can continue scrolling through those comments as you read before we wind up. But there was a question that goes directly to our organizers and to the Secretariat, and this was from Andrew. He was asking, who is a young lawyer and how many years of practice are considered for one to be a young lawyer? David, as you give your parting shots and as we come to the end of this webinar. You're welcome, sir.
Well, thank you very much, Laston. Thank you very much, colleagues. I think this has been one of our best engagements this year. When we prepared it, we thought it's a holiday time. We get the numbers that we need? But we have realized that people are really interested in this. The turnout was really quite good. Probably not up to the standards we normally have. The last webinar, we had 650 people. So I'm hoping the next time we have a young lawyers engagement, particularly set for young lawyers, we still can hit that number. But I believe we've done really, really well. You have been excellent, Laston. You've lived up to your billing as one of the best moderators we have in the region. To Ribin and Benedict, I think from the questions and the interactions we've had, this has been great. Your presentations were great. You are on point, and selecting you for this session was not by default. The committee actually looked at the work you guys have done. You are influencing work both in Kenya and Tanzania. And we thought this will be the best or the ideal candidates to speak about this topic to young lawyers. We did not want to have this mentorship in the form of getting older members in the profession to speak about a topic of this nature. So that's why you see we hired you. Both of you are quite young in practice. I might be wrong on this, but I know for sure that Ribin probably joined the profession at the same time as myself. Benedict has been there for a while. I remember when I joined ELS, I tried pushing a proposal through you when you were at Hivos, I believe. So this was a really great panel. I thank you. I thank our members who have taken their time before they exit. Let me just thank them for the time, for being here for the full 1.5 hours. We do not take that support for granted. And to respond to the questions directed to us, a young lawyer by definition, as of this moment at ELS, is someone who has been in practice for less than 5 years, so 0 to 5. I believe this is the same definition with ULS, LSK, TLS, most of our national bars. Or there was an age factor which has since been removed, where we had capped it at 35 years of age. So regardless of how many years you practiced, we thought after 35, you're no longer a young lawyer. But we still feel that if you were admitted at 33, really, you should still be considered as a young lawyer in the profession. So those are the parameters that we've been using. And then in terms of materials for this webinar, we are going to share the recording, the entire recording, just in case you missed a bit. I know some of us are still in offices and you might have to multitask. In case you missed a bit of the presentations, we're going to share that with you. We're going to share the presentations. Hopefully, Ribin, you'll be kind enough to share that with us. We will share it with everyone that attended this webinar so that they can be able to catch up on things they might have missed. Benedict, in case you have anything you want us to share with members, we will be open to sharing that with our members. Further, you can access all our webinar sessions, the recordings, and everything else on our YouTube channel, including previous engagements. So this is public information. We do not charge for our webinars, most of them, unless it's a really specialized webinar. So I'm thinking I'll start charging you, but then I will award points, CLE points for that. We are still in discussions with national bars, so that should you choose to want to get CLE points, you can pay, but still we retain the option of you can freely attend, but you do not get that point. So that's something that is coming up. You be on the lookout for that. And finally, thank you, Laston. Thank you, our presenters. Thank you, everyone, Secretariat and Young Lawyers Committee. Thank you so much. We really appreciate the work that you do. Thank you. Have a nice afternoon.
Bye-bye.